ladies and gentlemen, thank you very much for signing on today. As you can no doubt see, this is going to be a presentation which deals with the damages claims portal. The logic behind this particular seminar today is that I've been reached out to by a number of my instructing solicitors on quite a number of occasions, saying that they've either been caught out by someone using DCP in circumstances where they didn't expect it, or worse than that, they've been caught not using DCP in circumstances where they ought to have done so. Now, what I'm going to attempt to do today is go through how DCP works, what we can do to avoid being caught out, what to do if we are caught out, and make some recommendations for tactical decisions for what does look like an important part of the future of litigation. So a number of questions have already been emailed in. I will do my best to answer those questions which have already been put in the slides at the end of this webinar. Please do feel free to put your questions in the text chat as we go along. I will do my best also to deal with those one at a time as we continue. So, what is DCP? Well, it's the damages claims portal. It's a new online system for issuing claims operated by HMCTS. Issuing within DCP became mandatory for claims to which it applies in April 2022, and responding through DCP to those claims became mandatory on the 15th of September 2022. This is a pilot scheme. It is intended at present to run only until October 2024. I anticipate at the moment that that pilot scheme is going to continue in some more permanent format from that point onwards. It's a scheme which runs alongside other existing digital filing systems like MCOL and does not overlap to a significant degree with them for reasons that we'll come to. It is a complicated system. This guide is a guide from a lawyer's perspective rather than a guide from an IT perspective. So what I'm not going to attempt to assist with is technical questions about how to use the DCP website. That is out of my expertise. Although I have to say I found it fairly user-friendly and fairly intuitive in and of itself. What I'm interested in really is the litigation consequences of use of DCP and or failure to use DCP, identifying the circumstances in which it applies. There is a disclaimer to start with. I am personally, generally speaking, in favour of a more digitalised court system. It simplifies the whole process, it's more reliable, it's more straightforward to demonstrate what has or hasn't happened. It is simply the way these things are going to go for the 21st century. Here is a problem. I'm not a fan of the way the DCP has been implemented. I think it leaves a significant number of holes and a significant number of questions unanswered and creates obvious potential room for injustice. I will try to be as neutral as possible. I will flag out areas where I think there's a cause for concern. This is both to defendant and claimant litigants. Let's dive in. There's nothing more to be said about it except start going through the rules. As I say, there have been a number of questions at the outset of this seminar. It is an area that's caused a lot of people a lot of concern. I will attempt to answer those at the end. Please keep putting your questions in the chat box. If I can't, for whatever reason, answer them during the course of this seminar, I will do my best to get to it in due course. Be aware, though, because of what I said earlier, there may be perfectly good questions, indeed some very obvious questions, for which there is not yet any adequate answer. So, what are we talking about? CPR 51ZB paragraph 1.62. If all of the conditions in subparagraph 3 are met, which we will come to. The claimant's legal representative must register and secure access to the DCP system before the claim is started. The claimant must give the defendant notice, referred to in paragraph 1.9, which we'll come to, unless it's impractical to do so. The claim must be started using the procedure set out in this practice direction. So, if DCP applies, if the conditions in subparagraph 1.63 are met, which we're coming to next, the claim must be started through DCP. What happens if you don't? Well, very good question, and I don't think there's any satisfactory answer to that yet, but we will come to some of those considerations in due course. But before we get there, well, what are the conditions we're talking about? There's a lot. What you need to look at is subparagraph 3, paragraph 1.6 of the practice direction. Here's the first two. The claim is a claim for damages only, and the claim would not ordinarily follow the Part 8 procedure. So we're talking about a Part 7 claim for damages. Do Part 8 claims ever only involve a claim for damages? Don't think I've ever seen one that does, but suppose, or at least not a proper Part 8 claim, but suppose you did have that, you couldn't use DCP to make your Part 8 claim. Claim for damages only, claim that would not ordinarily follow the Part 8 procedure. This gets complicated. The claim is not one which could be started online using the production center under practice direction 7B. And what you have here are the requirements for a claim to be started under the practice direction. Beg your pardon, in the production center under practice direction 7B. So the first thing to say here is that over the next few sections, the language switches between double and triple negatives in places, so it's difficult to follow. The best way to think about it is if you could start a claim through the production center, or MCOL as we're about to come to, then you cannot start that claim using DCP. So, for example, with the production center, suppose you had a claim that had to be issued in the High Court. You could not issue that through the production center. Right? So you potentially could issue that through DCP. However, if you had a claim for a sum of money which is less than £100,000 and all of the other requirements are met, you potentially could start that claim in the production center. And so as I read these rules, you would have to start that claim using the production center in preference to DCP. A number of other requirements, most of which are repetitive, but the first thing to check, one of the first things to check, is whether this was a claim that potentially could be issued using the production center. And if it is, the practice direction part 7B is where you go for those rules. Essentially the same thing for MCOL. There are similar but subtly different rules for a claim that can be issued through MCOL, and it is a requirement for DCP that the claim is not one that could be started using MCOL. So again, for example, if you've got a claim for less than £100,000, potentially that's the sort of territory where MCOL could be used in those circumstances, assuming everything else is met. You would have to use MCOL in preference to DCP. And you have in the next two slides examples of the sort of situation which would exclude a claim from MCOL. Now, a lot of them, for example, a claim against a defendant outside the UK, also, rather unhelpfully, exclude the claim from DCP, but we'll come to that in due course. So what you need to check with these two provisions is, keeping it as simple as possible, is there another online system that already does the same thing, which would be easier to use? And if not, then you're still thinking about using DCP. And as I say here, the language is extremely difficult to get your head around. It's one of a number of problems with the practice direction. What I suggest there is that there is a simpler way of using it. You can only use DCP, or thinking about it rather, you can only use DCP if another system described in one of the practice directions of Part 7 is not more suitable. Okay, on to the next problem in the next provision. You cannot use DCP if the claim is made under one of the provisions of the Consumer Credit Act 1974 specified in practice direction Part 7b. Here is a glaring problem. The provisions for practice direction 7b, insofar as it relates to the Consumer Credit Act, cease to have effect on the 1st of October 2022. In fact, we know that because the current version of practice direction 7b deals with the production centre, not the Consumer Credit Act. And that's referred to just 2 paragraphs earlier. So apparently, you should not be using DCP for certain types of Consumer Credit Act claims, but it isn't possible to say which type of Consumer Credit Act claims, because the bit of the rules that dealt with this was deleted nearly a year ago. I will give the old provisions in the next slide, and this is not going to be of any interest to anyone who isn't dealing with Consumer Credit Act claims, but there are a range of specified provisions that were in CPR 7b up until October last year, aren't now in CPR 7b, but apparently still prevent you from issuing a DCP claim in respect of it. That is perhaps the greatest mess that I've ever seen the CPR get itself into in 12 years of doing this job. I don't know what to say. I have no idea how that would be enforced, what the consequences are going to be. It seems inevitable that at some point someone is going to tidy that up and either incorporate provisions relating to the Consumer Credit Act into practice direction 51ZB, or find some more creative way around it. I don't know. Or simply delete that requirement. I don't know. I don't know why you'd specify these types of Consumer Credit Act claims, but not other types of Consumer Act claims. Something's gone wrong there. I don't know what it is. Just be aware of that. If you're using DCP to issue a claim in respect of the Consumer Credit Act, you're going to have to deal with this at some point and simply flag up that the rules are a nullity. At some point, someone's going to have to include that in the particulars, it seems to me. Quite a number of hands raised. I will carry on. I'll come to questions at the end. But yeah, there's some sort of logical gap in the rules there. There will be a clear answer to that in due course, but at the moment, I'm not sure that there is. Moving on with some slightly more straightforward questions. The claimant has to be legally represented. A layperson acting as a litigant in person cannot issue a claim using DCP. There is no requirement that the defendant be legally represented, although only a defendant's legal representative rather can respond to the claim through DCP. There is provision that deals with that, and we'll come to it in due course. But it is quite counterintuitive. The claimant has to be legally represented. The defendant does not. What happens if the defendant is not is that essentially the claim automatically drops out of DCP, but we'll come to that in due course. The only formal requirement is the claimant be legally represented. The claimant must be an adult unless there's a litigation friend. Makes sense. The claimant, however, cannot be a protected party, full stop, even if there is a litigation friend. Why the rules would make that distinction, I can't imagine. I'm not aware of what's put on the spot of any other circumstances where a protected party with a litigation friend is treated differently from a child litigant with a litigation friend. But there we go, that's the rules. If you've got a protected party litigant, the claimant rather, and not a defendant, claimant, they cannot use DCP. If you've got a child, they only have to have a litigation friend. Yeah. The fee for issuing the claim is paid in full using any method paid by HMCTS. The claimant will not, before submitting their claim, apply for remission or part remission of the fee. There were a number of questions in relation to that. We'll come to those specifically in due course, but there's your answer. It used to be, not so long ago, that you could only use the DCP with the payment by account system. That's no longer the case. The only requirement now is that the claim be paid in full. I think most solicitors now are using PBA. I stand to be corrected on that. I think the days where you post a check to the court are now gone. But in principle, you could. If you've got a claim where there's an application for fee remission, you're not going to be using DCP. That at least makes a certain amount of internal sense. The claim is to be conducted in English. Doubt that's going to affect anyone here, but in principle, you can have Welsh language proceedings in Wales, but you cannot use DCP for those Welsh language proceedings if you were so minded. The claimant does not have in force against them a civil proceedings order, there's a civil restraint order preventing them from issuing the proceedings. That bit's perfectly sensible. If you've got a claimant who has one of those, you can't use DCP to make an application for permission to bring the claim. The claimant believes that the defendant has a postal address in England and Wales. So again, foreign national defendant, you can't issue outside of England and Wales using DCP. The defendant has to be 18 years or older. Whether or not they have a litigation friend is not a protected party. Whether or not they have a litigation friend isn't the Crown. Nothing too unusual there. Except possibly, again, the potential inconsistency between the child defendant and the child claimant with or without a litigation friend. The claim is not one to which the practice direction to Part 27b applies. Those are road traffic accident claims below the small claim limit. Can't use DCP for those. The claim has to be brought by one claimant against either one or two defendants, or brought by two claimants against one defendant. So a maximum of 3 parties, however distributed. Fair enough, this is intended for relatively straightforward litigation. If you've got multi-party litigation, it doesn't matter if all of the other requirements are met. You're not going to be issuing this through DCP. And take a breath. Those are the eligibility requirements for DCP. There are, in my view, so many exclusions that it's only going to be a fairly limited number of claims, or no, beg your pardon, that's not wrong. That's not right. A fairly limited category of claims which can properly be issued through DCP. And the big one of those is that if you've got a claim that can properly be issued through another existing system, you should be using that in preference. In general, that means probably a county court claim for an unliquidated sum of damages by a legally represented claimant, where the fee is paid in full, where there'll be no more than 3 parties to the litigation, and where another online system would not be more suitable. That probably will still catch quite a lot of litigation. But it may not. There may be there may well be whole areas of the law. It occurs to me if you're dealing with housing, you're claiming possession or claiming specific performance if you're for a defendant counterclaiming specific performance for disrepair. DCP just isn't going to touch that at the moment because it deals with the counterclaims for damages only. All right. So moving on, fairly straightforward rules in relation to the statement of truth. It's an electronic signature that will suffice for the purposes of the statement of truth. There is a complicating factor, of course, which we will come to in due course. But just bear that in mind. An electronic signature suffices for the purposes of the statement of truth provisions. Right. Prior notice to the defendant. If all of the conditions in subparagraph 2 are met, the defendant's legal representative must register with my HMCTS and access the DCP before the claim is started. notify the claimant that they are instructed, provide the claimant with their email address for claim notifications, and the defendant must provide the defendant's legal representative's email for claim notifications to the court using DCP, and must notify to the claimant using the procedure set out in section 3 of this practice direction, which we'll come to. The conditions referred to in subparagraph 1 are: the claimant gives the defendant at least 14 days notice of their intention to bring the claim using DCP, and the defendant has instructed a legal representative before the claim has started. A very wordy way of putting it: if you're going to issue a claim under DCP, what you have to do is you have to, if you have a defendant who is legally represented, you have to tell the defendant, not necessarily their legal representatives, but the defendants, at least 14 days before you issue the claim under DCP, that you're going to do so. If they do, the defendant's legal representative then have to sign up to DCP, register for an account if they haven't already, tell you that they're instructed. Presumably they've already done that if you know that they're there to give that the defendant's been instructed, has instructed legal representatives. All right, and you then have to provide the email address that they give you to DCP. Now that sounds fairly straightforward, but there's glaring errors in it. It all does presuppose that the defendant has a legal representative prior to issue, and of course they may not. But more importantly than that, or more immediately importantly than that, as I read the rules, it imposes a positive obligation on the defendant's legal representative to provide an email for service, even if the defendant has instructed legal representatives but has not instructed them to accept service, or the defendant's legal representatives are instructed to accept service but are not instructed or willing to accept service by email. As I read it, by electronic means rather. So as I read it, the DCP overrules the usual protections provided to defendants, legal representatives in those circumstances. And one of a number of questions that was put in relation to this is, well, what happens if the claimant doesn't do that? And it's a very good question. We'll come to this in due course. There is no sanction specified for failure to do so, though I probably would expect that to sound in costs if there was no good reason for that failure. So be aware of this. Claimant to notify the defendant, defendant to provide an email address to be provided to HMCTS through DCP. Okay, so we've got our claim, we've filled in the form, we've clicked send. It's indicated it then goes to HMCTS. The claimant has to complete the form using the DCP screens, submit the DCP using the submit button, pay any appropriate fee. Here's an interesting one. By selecting the submit button, the user, not the litigant, the professional user, verifies the brief details of claim, so the contents of the claim form, by a statement of truth for the purposes of CPR 22 and 3214, and requests that the court issue a claim form. Right, unless the document is uploaded to the DCP. Basically, if you want to submit any documents with your claim form, you have to do them with the, at this stage, you have to upload that onto the DCP and submit them at this point. Probably not going to want to do that. Almost inevitably, any documentary evidence that you're going to want to rely on goes with the particulars of claim. We'll come to that in due course, but in principle, it's an option at this stage. Now, what I'm more interested in, and what you should all be more interested in, it is that the act of submitting a claim through DCP constitutes a statement of truth by the legal representative in support of that claim, not as to the contents, but you're verifying with the potential consequences of a false statement of truth that either you or the client believe the contents of that claim to be true. Well, that's okay. The claimant cannot themselves sign that statement. The legal representative has to do it. That's going to have a significant knock-on effect for at least some legal professionals at some point. And more to the point, it's going to undermine, from a defendant point of view, a lot of potential for arguments of fundamental dishonesty if you're personal injury litigators, or allegations of fraud or contempt of court. This is going to have enormous implications, in my view, that someone at some point needs to sit down and think about much more carefully than's happened up till now. But the point to take away from this is that the act of submitting a DCP claim indicates or amounts to a statement of truth. Right. Documents received by the court. We'll deal with this now because it's dealt with first within the rules here. Where a document is required in support of the claim, for example, a medical report in a personal injury claim or a written copy of the contract in a breach of contract claim, those can be served with DCP. These generally need to go with the details of claim, which is the DCP term for the particulars of claim rather than the claim form. But it can be done at any time from the date of issue. Beg your pardon, no, disregard that, from the date it's submitted through DCP, which is tantamount to service of the claim form, filing of the claim form. Paragraph 1.8a, we skipped over this, we'll come back to it now. Where the document is uploaded to the DCP, it is for all purposes filed with the court. If a document is served and can be uploaded to the DCP, the document may only be served by uploading it to the DCP. Okay. Service is deemed to have taken place at the time and date at which the notification is sent by the DCP to the party being served, and the document has been uploaded to the DCP. So you want your medical report in support of a personal injury claim. You've got it ready at the time. You've got the particulars of claim ready, or the claim form ready to go on DCP. You upload that medical report to DCP. When it gets served, which we'll come to in due course, that counts as a service on the defendant. Okay, not the worst area. That makes a certain amount of sense. Issue. Not so sure about this bit. The court must notify the claimant by email when the claim is received by the court. Fine. Notification of receipt does not constitute notice that the claim form has been issued. Fair enough. The court must issue the claim form when payment of the appropriate fee is confirmed. Fair enough. The claim is brought for the purposes, here we go, the claim is brought for the purposes of the Limitation Act 1980 and any other period of limitation at the point at which the claim is issued and not before. CPR PD 7A paragraph 6.1 does not apply. Oh boy, anyone who knows what that is, you'll see why I have such a significant issue with this aspect of DCP. We'll come back to that. The court must notify the claimant by email when the claim is issued. Fair enough. Must provide the issued claim form to the claimant rather by DCP. Fair enough. If the defendant is not represented by a legal representative who is registered with my HMCTS, even though it's a mandatory requirement that they become so registered if they're a legal representative acting in those circumstances. Okay. The claim will be automatically transferred out of the DCP immediately after it is issued to continue under Part 7. Fair enough. Makes a certain amount of sense. Gets around that problem we talked about with the defendant's legal representative earlier. There's then various technical provisions we'll come to transfer out of the DCP towards the end of this presentation. That is not what I'm concerned about. Far and away, the most significant issue here is the limitation point. Why does that matter? Well, under the usual rules, if you send a claim form to the court for issue before limitation expires, and the court issues it after limitation has expired, you're fine. That's what paragraph 6.1 of Practice Direction 7A says. Here, no. If there is a delay on the part of the court, which takes issue through DCP until after limitation is expired, the claim is no longer good. Limitation has effect. The defendant has a complete defence to that claim, even if the court has acknowledged receipt in good time, even if you send it in perfectly good time. And if the court delays and that causes limitation to expire, it's very tough. That's not even careless drafting, it's deliberate, because someone consciously decided that Practice Direction 7A paragraph 6.1 had to be excluded. Someone is going to lose out here. There's absolutely no question about that, or someone else is going to obtain a windfall, depending on how you look at it. and it's not going to be through any fault of their own, may well not be through any fault of their solicitors, may well be through fault part of HMCTS. Watch this space. We can only hope that issue is more or less instantaneous using the DCP. It's clearly intended to be that. One hopes there isn't an IT outage. One hopes that this doesn't need particular attention from court staff. Someone's going to get really caught out there, and at the moment, I'm not sure what you could do about it. There might be certain circumstances where you can seek to disapply the limitation period in those circumstances, but it's going to be very, very difficult. If you're going to be issuing a claim using DCP, do not play fast and loose with limitation. Get it issued as quick as humanly possible. Gives you quite a bit of time to get the claim form and the particulars served. We'll come to that. This is not a system to be used for last-minute issue. Notifying the defendant. The claimant must notify the defendant of the claim through DCP. Essentially, this is service. Notification of the claim constitutes service. Where the defendant, is notified of the claim, all parties must be notified of the date of notification, and the defendant must be notified of the date of issue of the claim through DCP. So, just in case you thought you were going to get away with a limitation point, it's a mandatory requirement to formally notify them of the date of issue. The claimant must comply with this. This is fairly familiar territory, and you'll see where we're going with this as we go through it. The claimant must comply with paragraph 3.1, so that's notification service, by 12 midnight at the end of the calendar day, 4 months after the date of issue of the claim form. Paragraph 1.7 excludes certain public holidays, nothing unfamiliar there. If the claimant has not notified the defendant of the claim by that time, the claim will be automatically dismissed without the need for further order. If the claim is dismissed under paragraph 3.3, any application extending time allowed by paragraph 3.2 must be made by application for an order under CPR 7.6. 7.6 is territory which I suspect is going to be familiar to most people here. Basically, if you can't get the claim served within your 4 months, you make an application in time to extend that period. It must be made in time in almost every circumstance, in almost every case. If you make your application out of time, you have to show that you took all reasonable steps to serve the claim form in time. This will be exactly the same under DCP as it is under the usual rules, and it's a major headache. People get this wrong all the time. An application made in time to extend time is pretty straightforward. An application made out of time to extend time is very, very difficult, and you're at immediate risk of an application under Part 11 for the court to refuse to exercise jurisdiction. If you get this wrong, that's pretty much the end of your claim. So you get it served within the 4 months. If you can't get it served within the 4 months for good reasons, you apply for an extension of time in time. You're really at last chance saloon if you're making an application to extend time retrospectively. Okay, but all in all, this is fairly sensible provisions relating to service of the claim form. Although notifying the defendant of the claim is what we call it under the DCP. Notification of the claim or any documents to be provided may be amended or added to using the DCP at any time before they've been notified to the defendant. So this is the equivalent to amending before service under Part 17.1 in answer to a number of questions that dealt with that topic. So you can amend before you serve, but you must serve in time. Details of the claim. What we would call the particulars in any other piece of litigation. The claimant must provide details of the claim, which is to say the particulars of the claim and any supporting documents, medical report in a personal injury case, contract in the contract case. There are a number of other circumstances where it's mandatory to provide a document with the particulars of the claim. This must be done through the DCP by completing the relevant screens, fair enough. unless the document cannot be uploaded to the DCP, any document which the claimant wishes to file and is required to file must be uploaded to the DCP. Okay, hopefully everything can be uploaded to the DCP. The details must include the information required by CPR 16.4. So essentially the same rules apply to the details of the claim as apply to the particulars of the claim. And the details of the claim and any documents provided may be amended or added to using the DCP at any time before they've been notified to the defendant. Same thing, analogous to amendments prior to service. That bit's fairly sensible, I think. I don't think that's going to cause any particular headaches that I can see. This bit might. The claimant must notify the defendants of the details of the claim before the earlier of the time specified in the paragraph 3.2. So if you're pushing up against the end of your 4 months, you have to get the particulars of claim in but before the end of those 4 months. Or 4 p.m. on the 14th day, not midnight, 4 p.m. on the 14th day after the defendant was notified of the claim. All parties must be notified of the date of notification through DCP. If the claimant has not notified the defendant of the details of claim by the time specified in 4.4, the claim against the defendant will be automatically dismissed. So you're struck out. Any application for an order extending time allowed under paragraph 4.4 to reinstate a claim struck out, dismissed, under paragraph 4.5 must be made by an application which must go to the CCMC. So it goes out of DCP, and effectively it goes out of DCP at that point. There's an application to the County Court Money Claims Centre to reinstate or to extend time. Now, we don't know exactly how this is going to work for DCP, but if this had happened in the old paper system, that would be a fairly straightforward application for relief. You wouldn't necessarily have too much of a problem getting that application in. It isn't traditionally seen as being as high a threshold as the applications under CPR 7.6. But I would still get that application for an extension in time, particularly if you're dealing with anything which engages the 4 months after the notification of the claim form being served. I would certainly encourage you to make that application early, and if you're a defendant, look out for the possibility of the claimant getting that wrong. Let's say one of the sides. This does seem like reasonably familiar territory. I don't think this varies to a very significant degree from the normal provisions for particulars of claim, but something to bear in mind. Right, acknowledgement of claim, acknowledgement of service, in other words, but it doesn't work in exactly the same way. The defendant may acknowledge the claim after notification of the details of claim. So after the particulars, not after the claim form, as you might expect, but within 14 days of the date of the particulars. All right. You must do so, the defendant must do so, if the claimant wishes to, if the defendant wishes to dispute jurisdiction under Part 11. So, for example, they've served outside of the 4 months allocated. That's the most common situation. There could be others. If that happens, the claim gets transferred out of DCP, and we'll come to how that happens and what that looks like towards the end of this presentation. The defendant must file acknowledgement of claim within 14 days if they intend to do so. So that's pretty much the same as an acknowledgement of service. It is mandatory if you want to dispute jurisdiction. It does, however, extend time for the defence in the usual way, and we'll come to that just in a moment. We don't call it a defence anymore under the DCP. We call it a response to the claim, but substantively it's the same thing. The defendant must respond to the claim by the time stated on the DCP, which we'll come to. The parties may agree an extension of time without making an application, provided that only one extension may be agreed, and that extension is of 28 days. That must be recorded on the DCP. So the parties can agree between them an extension of time for 28 days. Other than that, it needs an application for an extension of time. The time for responding to the claim is 4 p.m. on the 14th day after the claimant notified the defendant of the details of claim, so 14 days from the particulars if no acknowledgement of service, and 28 days if there was an acknowledgement of service. So that works more or less the same way as paper litigation always has, or such other date stated on the DCP following the agreement of the parties under paragraph 6.21. So if they agree an extension of time, that's the time that takes effect. Again, this is slightly different, but not fundamentally so. I think it's unlikely this is going to cause any very significant headaches that wouldn't have been caused by the ordinary run of litigation. There's still the same fairly tight time limits. You can agree an extension. You can always apply for another one if you're acting for a defendant who needs more time to get a defence together. 6.4, the defendant must respond to the claim through the DCP. Admit all or part of the claim, or wishes to make a counterclaim rather, the claim is automatically transferred out of the DCP. So, interestingly, the DCP isn't suitable for claims where there's a partial admission. Right. Well, it is, but you cease to remain within the DCP once that partial admission is made. If there's a counterclaim, it's not treated as suitable for the DCP. It gets transferred out to the DCP system. So even if you get to this point, it seems to me that's going to knock out quite a lot of claims. The only circumstance where you go further than this through the DCP is if there is no counterclaim and there's a complete denial of liability. There's no specific provision, interestingly enough, for what happens if you have another additional claim other than a counterclaim. In principle, you could make a claim for a contribution, or for an indemnity, or a third-party claim under Part 20 without this rule applying, such that you wouldn't come out of the DCP system. Very odd. But you know, there we are. Those are the rules. There are certain specified circumstances which trigger the claim coming out of the DCP, but other closely analogous circumstances don't. I suspect that is because no one thought of that, which rather reinforces the concerns that I have about the rules in this area. 6.5. If the defendant, well, here we go. This is the more route. This is the more conventional route. If the defendant indicates that they will defend all of the claim, they must submit details of their defence. Fair enough, and their directions questionnaire at the same time by completing the relevant screens and selecting the submit response button on the DCP. Fair enough. Presumably, that also has the effect of the legal representative signing the statement of truth in the defence. It doesn't specifically say so, but presumably it has that effect. The defendant's response must include information required by 16.5, so the response must have the same information you'd include in a defence, nothing complicated there. Unless the document cannot be uploaded to the DCP, any document which the defendant wishes to file or is required to file with their defence must be uploaded to the DCP. Again, straightforward enough. We've dealt with that before. The claimant must be notified when the defendant has submitted details of their defence. Call it a defence here, but a response elsewhere in the rules. But there we are. When the defendant has submitted details of their defence, the claimant must be notified, and all parties must be notified of the date of the date of notification and the date by which the claimant must provide initial case management information, which we will come back to. Well, to my mind, by far the most interesting provision there is that direction questionnaires must be submitted with the defence. And the observation that I make is that whilst this is mandatory, and there is no obvious way of getting out of that whilst complying with the DCP, there is no internally specified a penalty for failure to comply. But the court does have jurisdiction under Part 26.3, which we will come back to impose penalties for non-compliance. So defence, more or less what we might have expected. but there's a fast forwarding from there to the defendant's direction questionnaire. Default judgment: if the defendant does not respond to the claim by the time specified in 6.3, the claimant may ask for judgment. The claimant requests judgment through the DCP as described. Judgment may be requested in essentially the same circumstances as it might be requested if you are if you're on the paper route. The defendant does not respond to the claim. The defendant does not apply to strike out the claim, or if the defendant has applied to strike out the claim, that application has been disposed of. No party has applied for summary judgment, or that application has been disposed of. The defendant has not satisfied the whole claim. Nothing unusual there. Essentially the same requirements for a conventional judgment in default. There are, however, certain circumstances where you can't apply using DCP, and you have to apply on paper. That is if Rule 12.11 would apply. In other words, you've got a type of claim for which a default judgment is not normally suitable, or there's some sort of moratorium in place under the 2020 regulations. In those circumstances, a request for judgment has to be made on paper to the CCMCC. There we are. Pretty much works the same way as you would expect. 6.7, if the defendant fails to respond to the claim by midnight on the date 6 months after the date of notification of the claim, the claimant has not made a request or applied for judgment under CPR 6.6. So if you've got a defendant who has replied and a claimant who hasn't sought default judgment, and the claimant hasn't made an application for the claim to come out of the DCP, which we'll come to, then the claim is automatically dismissed. And there's comparable provisions for these rules in the ordinary paper route in the CPR. Okay, so if you're a defendant, get your defense in. If you're a claimant and they haven't, make sure you get your application for default judgment in within 6 months, because if not, a claim will be automatically dismissed. And I overlooked this earlier, you can apply to reinstate, but you have to make a paper application to the CCMC. Right, directions. If the defendant responds to a claim with the defense, the claimant has to respond in kind. They have to indicate whether they want to continue with the claim. Fair enough. And if they do want to continue with the claim, provide hearing information using the DCP. That's before 4 p.m. on the 28th day after notification of the defendant's response. And if that doesn't happen, the claim is transferred out of the DCP. Going to come to that in a moment, and will be transferred to a county court hearing centre, and it will be treated as if the claimant did not file their directions questionnaire. So in other words, the claimant has 28 days from the date of receipt of the defendant's defence and directions questionnaire to respond with their own directions questionnaire. And if they don't, they're exposed to sanctions under 26.3.8. 26.3.8, for the sake of completeness, is a very woolly provision. The court can impose almost any sanction it thinks fit. It can order directions, it can strike out the claim, it can strike out the defence and enter judgment. And it can list the claim for a case management conference. So which of those the court is going to do is, again, not for the first time left up to the individual judge, and not entirely spelled out. I doubt many claims are going to be struck out for non-service of a directions questionnaire. Probably more likely to end up with an unless order both ways, but it probably is going to sound in costs. Okay. The last point, not the most exciting of these on directions, CPR 26.4a does not apply to claims using the DCP, so there's no referral to the mediation service. There we are. Enough said there. Why the distinction? I don't know, but that's such is life. Cost budgeting. This is an important provision, I think. In those claims to which Section 3 of Part 3, Practice Direction 3D applies, CPR 3.131A is disapplied, and all parties except litigants in person must file and exchange cost budgets with 3.31b. What's that talking about? Cost budgets in many circumstances have to go with your directions questionnaire. Because we're fast forwarding to direction questionnaires in these circumstances, you can't do your cost budget with your direction questionnaire. So instead, you have to do your cost budgets 21 days before the first case costs and case management conference, full stop. That does simplify the process somewhat, even if you were in the position where you had to, in ordinary circumstances on paper litigation, get your direction question in, get your cost budgets in with your directions questionnaire. No, you're exempt from that under the DCP because of the peculiar rules surrounding the direction questionnaire, and you get it in 21 days before the first CCMC. That's about the first sensible concession, I think, that the DCP rules have made so far. Exiting the DCP, not a huge amount to say about this, but we'll go through the rules anyway. A claim may at any time be transferred out of the DCP. Either party can make an application on paper to that effect to the county court. An application may include an application under Part 23 that the claim proceed as if it had been started under Part 7. That makes sense because these would normally be Part 7 claims if you weren't issuing under the DCP. Where a claim has not already been transferred out of the DCP, but the court at any stage concludes that the claim is not suitable for the DCP, or is no longer suitable for it, or is otherwise not appropriate for it, a judge must transfer the claim out. Unless otherwise stated, a claim which is transferred out of the DCP continues as if it had started under Part 7. So why would you need an order? Why would you need an order to the effect that it should? But there we are, you can make that application. And a claim which has been dismissed at the point it is transferred out of the DCP remains dismissed, subject to any order of the court. Fairly self-explanatory, I suggest. So let's just break that down. The parties can make an application, or the court can make an order of its own volition taking the claim out of the DCP. There are no specified circumstances in which this will happen. It's not clear to me, at least, whether this applies only to erroneous commencement through the DCP, or whether there's some sort of merits-based approach. Certain types of cases are seen as not suitable for DCP, even though they're eligible. I don't know. It's not been specified. But the other follow-on consequences, I think, are fairly intuitive. If I had to take a guess, I would say that the courts would only make such an order of their own volition, certainly, if the eligibility requirements weren't met, for example, and the claim had been started through DCP in error. And both parties would, I think, be justified in making that application were that position to arise. They might question what happens with costs if you've got a claimant who's issued under the DCP wrongly. Discontinuance. To discontinue a claim or part of the claim, the claimant complies with CPR 38.31a by filing a notice of discontinuance at the CCMC. In other words, if you want to discontinue your claim, you can't do that on the DCP. You have to do it on paper to the County Court Money Claim Centre. Similar sort of thing with changing legal representative. I'm not going to read that all out, but to change your legal representative, you have to serve notice pursuant to CPR 42 on paper at the CCMC. Can't be done through DCP. Begs the question, why not? But there we are, you can't do it. Last point on the rules, and I mean the last point on the rules, fees. A party can only take a step using the DCP on payment of the relevant fee, and it must be paid by 4 p.m. on the date it's due. So, fairly self-explanatory. The only obvious area is the issue fee, one would think. That could be a certain other fees that apply. If you have to pay that using an approved system through DCP for a step which requires a fee to be effective. And take a breath. That's how DCP works. It's a mess. I stand by what I said at the start. there's going to be a problem. People are going to get their fingers burned with this. What I'm going to do now is I'm going to break down a summary of what we've talked about, and then I'm going to go through questions that have been asked. I'm going to start with questions that were sent in before this seminar, and then I'm going to try and deal with any questions that come up during the course of this seminar to the best of my ability. So, first things first, you want a claim which you think has to be issued. You do want to check if it's one where DCP has to be used, or indeed can be used. If you think it can, and indeed must, you must notify the defendant of your intention to do so at least 14 days beforehand. You then complete the claim form online. The court then acknowledges receipt, and sometime thereafter, once the fee's been cleared, the court issues the claim form. Now, this has to be done before the expiry of any limitation period. The defendant then notifies the defendant of the claim form, serves the claim form. This must be done within 4 months, and notifies the defendants of the details of claim. Generally speaking, this must be done within 2 weeks, unless the 4 months would run out sooner. The defendant acknowledges the claim within 14 days or 28 days in the usual way, following an acknowledgement of service. We must include the directions questionnaire with that. The claimant responds within 28 days with his own directions questionnaire. Case management directions are then given, and the claim proceeds. Fairly ordinary directions and allocation should follow from that point, and that's as far as the rules take us. So there we are. That's what we need to know about DCP. I flagged up areas where I think there are significant litigation issues. These slides are, of course, going to be made available to attendees at this conference for future reference. Answering your questions then. I'm going to start by this with an important disclaimer. There have not yet been clear answers in case law to any of the obvious questions that DCP raises or potentially raises. My answers to your questions are my own personal interpretation of the rules. Court might come to a different view. I'm going to flag up as far as I can areas where I think that's possible. There are areas where there are some fairly cut and dry answers, and where that applies, I'll do my best to flag that up. So bear that disclaimer in mind. I will do my best, but this is still very early days with DCP. There aren't any cut and dry answers like that. There aren't enough cut and dry answers yet. The first set of questions that people have sent in were the most obvious, and the gist is, what happens if the claimant doesn't use DCP and should have done? And remarkably, the answer is, I don't know. There is no specified sanction for non-compliance with DCP. It's a mandatory provision, but what sanctions are imposed for breach is left to the individual judge. It's also left to the individual judge to determine even if there is an implied sanction. So it doesn't say, for example, a claim may not proceed unless issued by DCP. It doesn't say it will be struck out. It doesn't say that it will be recommenced as if it had been issued using DCP. It doesn't say that there'll be cost penalties. Now, just about any of those is open to interpretation. A court might look at it and say, well, okay, it's non-compliance, but so what? You've got a paper claim. It hasn't caused you any additional costs. A court might look at it and say, well, no, this was a mandatory requirement. You had to issue it in this way. You had no choice. I'm going to strike the claim out. Until such time as there is a reported determination on this point, an adequate one, that there is no answer to that. And that's very, very unsatisfactory. There will be case law on this point. I cannot imagine that there will be. I will be surprised if there are not already cases making their way through the system that deal with these points, but it hasn't yet, that I know of, certainly got to the point that there's a reported determination on it. I'm going to be interested to find out. Watch this space. If you're for a claimant, try and get it right. If you're for a defendant, flag up when the defendant has got it, beg your pardon, when the claimant's got it wrong, and threaten to make an application, but do so very cautiously, because very unclear what the consequence is going to be. Right, second question, a much more straightforward one. If the claimant is seeking fee remission, can they use DCP, or are they exempt from DCP? Well, I would say no, they can't, and yes, they are exempt. That's because paragraph 1.63GA, it's one of the very early slides, creates an exemption where the claimant is applying for fee remission. There's no requirement for the claimant to use DCP. In fact, I would say that DCP is not available to them in those circumstances because the claim could not be issued. And that point is made, not issued until the fee is paid, not remitted but paid. And that point is made repeatedly, the most obvious one being paragraph 9.1. So that, I think, is a fairly clear answer. The short answer is fee remission, no, not using DCP. What sanctions are available where a claimant fails to give prior notice of the intention to use DCP? Another really good question. Another answer where the answer is, I don't know yet. No one knows yet, I don't think. It's mandatory unless it's impracticable to give that notification. But again, there are no specified sanctions and it's left entirely to the individual judge. Realistically, I would expect that to sound in costs. I would say it's analogous to failure to file and serve an appropriate, to serve an appropriate letter before claim. That's what I'd expect. But it could have a much worse situation than that. What if you simply fill in the DCP form with an email address that the defendant's legal representative has not authorized to be used for DCP purposes? Well, in that case, you might have found that you've ineffectively issued your claim, or at least served it. So try to get that right if you're for a claimant, and do, if you're for a defendant, kick up a fuss and point out and threaten to make an application, actually make an application if necessary, if you've got a claimant on the other side who gets this wrong. What should you do if you're dealing with a borderline case, one where it might be issued under DCP, or should another system be used? If a claim is unsuitable for DCP, can it be transferred out? There's a lot of questions, a lot of different questions that focus on the same topic. What I'd say to that is that type of claim which falls within DCP is, well, the flaw with paragraph 1.63 is it's overly complicated and overly detailed, but it is extremely specific. There's not really an evaluative process unless one is implied by paragraph 8.4. That's when the claim comes out of the DCP, or might, on the cold zone initiative. In my view, a claim is either qualifies, and so it's mandatory to use DCP, or it doesn't, and so it's forbidden to use DCP. There's a difference, in my view, between something which is a system which is complicated and a system which is ambiguous, and this, in my view, falls squarely towards the former. I don't see many borderline cases. There might not be any borderline cases, but there will be very complicated assessments. I'm afraid that's all I can really say to that. It can't really be avoided. If a claim is eligible for an existing digital system, in answer to the question, person who put that question, that system should be used instead. We're thinking MCOL or the production center here. The reason for that is the DCP rules say so specifically, at least for now. One wonders if they won't all be consolidated at some point in the future. How do you come out of the DCP? Well, you can make a paper application under paragraph 8.2 of the practice direction. Okay, just a few more of these. Can the claim form be amended before service? And if so, how's it done? Yes, straightforward answer to this one. Paragraph 3.2a deals with that, and it can be done online using the DCP system. You can amend either the claim form before service or the particulars before service. You can do that online. Can time to file a defence be extended under the DCP? Yes, it can, by agreement, a single extension of 28 days. So it's more stringent than the ordinary rules, but basically the same system applies. Anything more than that needs an application. Can you avoid filing the directions questionnaire, the allocation questionnaire with the defence? No, I don't think you can. It is a mandatory provision. CPR 6.5 says as much. Same applies to the claimant when they reply to that. However, again, the rules impose no express sanction for failure. it does expose you to an application for an order under Part 26(3). Honestly, the main redeeming feature, it's not the best feature of DCP, to put it mildly, but the main redeeming feature is that you don't need to do costs budgets with that directions questionnaire. So, but usually by far the most significant risk of getting this wrong is it doesn't apply. And the last question that was asked beforehand, if the author of this question is online, I'd be interested to hear where they're coming from with this and why they think it might be. I was asked if a claim involving an assault by a pupil on a teacher would be excluded from the DCP. In and of itself, no, but there are circumstances I can imagine it being excluded. For example, if there are more than two defendants, so suppose you sue the school, the pupil, and the local authority that runs it. If the litigation friend was under 18 and was a defendant, they would be excluded. That would be excluded from the DCP. If there is a claim for some remedy other than damages, that would be excluded from the DCP. If the value is under £100,000, it might well be more suitable for an MCOL claim. There's quite a range of possible circumstances where that could happen. Not quite sure how to best to approach that question. I feel like there's a more specific detail that's been missed. I'm very happy to engage in dialogue about that by email. Those were all the questions that I was asked. Now, there have been a very large number of questions in the textbook, so I'm going to go through those now. If I cannot get to your question in time, I apologize. I appreciate people need to leave, and I've taken more time for this seminar than I said I would. I'm going to leave my email address up on the slides for the moment whilst I go through the rest of the questions. Please do feel free to email me. I will do my best to answer all of them. So, questions. What happens if you issue protectively against more than two defendants, but you then proceed to serve only two or less? I would say that you cannot issue a claim using DCP, protectively or otherwise, against more than two defendants. So you simply couldn't do that using DCP. You would have to, and that's one of the sub-provisions, paragraph 1.63 says as much. If you wanted to do that, you'd have to issue on paper, or unless there's some other online system that will allow you to do it. I don't think so. You'd have to issue that claim on paper. If applying for fee remission, do you do so after issuing the DCP and then request a refund? No. Well, there's an interesting thought. You couldn't simply issue on DCP using a fee waiver request. You simply couldn't do that. It's not an option. Could you pay the fee and then apply for a refund? The rules don't specifically say that you can, and they don't specifically say that you can't. My instinct is that would be the sort of situation that would trigger the claim dropping out of the DCP. But that's just a best guess. I'm not aware of case law that deals with that, and the rules don't deal with it specifically. So I would say you could try that, but it would probably simply lead to the claim falling out of DCP. Not that there's necessarily anything wrong with that. Okay, if limitation is determined by the date of issue, then when is the safe period to file the claim forms? Two months sufficient to allow the court to issue and notify? Well, there's your problem. Generally speaking, I think that's going to go in. I suspect, in practical terms, I think that claims are going to be issued pretty quickly under DCP because it's probably an automated system. So I don't think this is going to be quite as much of an issue in practice as I suspected it might be on paper. But yeah, look, what's the usual practical experience? Claim issued by a county court about 2 weeks after you file. I certainly wouldn't want to use DCP within that sort of time limit, but then you might not have a choice. So get it done as quickly as possible. The suggestion was, would 2 months be sufficient? Probably, in most circumstances, I would have thought so. Okay, we have to file direction questionnaires, the next question, but need to stay the claim for approximately 3 months and need to make an application and pay the appropriate fee. Can we do this on DCP? Right. I would say that you could include the request for a stay in your direction questionnaires as either defendant or claimant, presumably a claimant in that situation. But if you wanted to make that application, there's no specific provision for the making of that application within the DCP. So that's probably a paper application to the CCMC to be consistent with the remainder of the rules. That's what I would anticipate. If we issue for, so next question, if we issue for £75,000, but during the 4-month stay, new evidence is received which indicates a pleaded value of £150,000, do we have to apply to exit the claim from DCP, or do we, as I've done, email the court separately asking that the additional fee be deducted from the PBA account and uploaded to an amended claim form? That's a tricky situation. Your experience, Dan, was it that the court was happy with that? That implies a greater degree of flexibility than the rules do. Let's put it that way. My instinct would have been that you probably would need to exit the DCP in those circumstances. Having said that, if your experience has been that the court was happy to be flexible in that regard, what's probably happened is it's been referred internally by a member of court staff to the sitting judge who's approved that. That's my best guess. My instinct would be what you would have to do is make a paper application under Part 23 to the CCMC. If the court had not been so flexible, the reason I say that is that you then have a claim form and indeed particulars or the DCP equivalent, which specified a much lower value of claim, had been served or notified to the defendant, and then formally needed an amendment. So, in those circumstances, I would say probably, if push came to shove, you need to make a paper application for an amendment. But I'm relieved to see that didn't happen in practice in your case. Okay, next question. If we've given 14 days notice to a defendant's solicitor of filing claim for DCP, we file it immediately, but then a court delay with service after limitations passed, surely that would prompt a Section 33 application. Oh yeah, or the defendant would criticise raising limitation. Yeah, but there are circumstances and there are types of claims where where the limitation period simply can't be disapplied. It can be in personal injury claims. It can't be in certain other types of claims. There are only very specific circumstances in which a disapplication application can be made. Would the defendant be criticised for raising limitation in those circumstances? Probably, but what's to stop them from doing so? Does it debar them from raising that defence? This is going to cause a problem, and I just do not see how those rules are indefinitely sustainable. Can I file particulars of claim as a document, or must I always complete the screen? Is the next question. As I read Part 6 of beg your pardon, Paragraph 6 of the practice direction rules, I would say that it has to be done through the DCP system, filling in the screen. I don't see how particulars of claim separately uploaded as a document, although that would count as proper service. I don't see how it would count as proper notification of the details of the claim to the defendant for the purposes of the practice direction. It might, in practical terms, be overlooked. I can well see that. And I think last question that I've got. PI claim to issue limited to £75,000 may need to increase to over £100,000 with amendment prior to service. Should we be using the DCP? Off the top of my head, two things come to mind. Firstly, you can amend prior to service. That's not a problem. The only in fact, if anything, the extension to value over £100,000 would point in point in the direction of keeping that within the DCP. And the reason I say that is that, off the top of my head, I think the MCOL limit is £100,000 off the top of my head. I don't think it makes a difference either way. But my instinctive reaction is there's nothing wrong with amending prior to service. You can do that. There's a specific provision within the DCP rules for that, and there's a provision on the website. And there we are. That's all the questions I've got in the Q&A box. Thank you very much to everyone who's still here. What I'm going to do is I'm going to try and go through the text box and see if I can identify any questions that have been put in there. I will do my very best to answer those. So, but please bear with me. This is not the most straightforward system to use. Right. Will it be possible to claim specified amounts through the DCP portal? I handle RTA recovery claims at the moment. We're still issuing them on paper. Well, I think if you're issuing a claim for a specified amount of money only, that's probably, unless it's very high value, going to be MCOL suitable. So it's probably not going to fall within DCP. If you're dealing with a claim which has an unspecified amount of money, for example, PSLA, as well as a specified amount of money, it probably isn't going to be MCOL suitable. So yeah, you're probably into the point where you do have to, or at least have to start thinking about issuing those under DCP. Can't off the top of my head think of any circumstances where you claim a non-financial remedy following a road traffic accident claim. So yeah, I think that probably is the territory where we're talking about using the DCP. An observation matching the observation I made, should court system be moving towards technological services? Yeah, for all my criticism of the DCP system, I'm not criticizing the incentive to digitalize all of this. In principle, I don't have a problem with that. My problem is with the way that DCP is structured, not with where it's trying to get to. Yeah, agree with you. Agree with the assessment there fully. Will the recording and slides be available afterwards? Both, yes. There'll be slightly tidied up slides and a slightly edited recording to hopefully cut out the periods of time when my internet dropped at the start. That will be on YouTube at the least, and the slides will be coming around to all of the attendees and everyone who signed up. Again, those will probably be slightly tidied up, so don't be alarmed if there's subtle differences. It's just there's always a proofreading process. Are we able to use MCOL for a disputed RTA matter? Now, I might be completely misremembering it, and if I am, disregard. I am absolutely sure that one of the requirements for MCOL is claim for a specified sum of money. Almost completely sure of that. And in fact, I'm pretty sure that's one of the provisions of paragraph 7, the big pardon, practice direction 7C. So no is the short answer. For an unspecified sum, I don't think you can use MCOL. Let's see. Good. What if the defendant's insurer is dealing with it and they have an in-house legal team? Yeah, there's been a fair bit of dispute about this. Now, the rules only say it has to be a legal representative. If you've got an in-house legal team, presumably they're an in-house. Presumably they qualify as a legal representative. I can't see any reason why not. But there's been a bit of an argument over this in the press. So long as you're able to set up a DCP system, which I suspect the in-house legal team will have, I don't see an issue on paper. Someone else may see an issue that I don't, but I don't see an issue on paper. But even if you get that wrong from a claimant point of view, the worst case scenario is it just automatically drops out of the DCP. Not much else to be said to that. I don't think that's going to cause a huge headache. But my view is nothing wrong with the in-house legal team doing this. We've had defendant insurers require us to give notice to the defendant directly, which seems odd. I agree. I don't know what's happened there. I haven't come across that before. I think the insurers are making a mistake there. In those circumstances, I would say that you could still, in principle, issue under the DCP. But if you're serving on a defendant directly, presumably that they don't count as legally represented, most likely. Suppose they could have representation separately from their insurer, possibly, but generally speaking, they wouldn't. In that situation, you'd automatically drop out of the DCP under paragraph 2.2. Yeah, here's a really good question. We're a defendant insurer. We don't accept service of proceedings by email. We require the defendant to be served. Okay, fine. That makes sense. I have every sympathy with people who don't want to accept service by email. Under any other provision of the CPR, it's a matter for the defendant insurer. As I read the rules, it becomes mandatory. And I'm not sure there's much more I can say about that. I have every sympathy, as I say. If solicitors are instructed, are you meant to notify the defendant directly? But no, under the DCP, there's an obligation for, as I read it, gone through this a couple of times now, there's an obligation for the defendant's legal representatives to accept service. As I read it, it is a little bit more complicated than that, but there we have it. Can you amend a claim form now on the DCP? I've done this a couple of times and it seems to take it out of the DCP portal. It shouldn't. In principle, you can. But unfortunately, as I say, this isn't a technical guide to the DCP. It's more a guide to the legal principles that underpin it. And I wouldn't be the right person to ask for help with that. Can you amend? Yeah, but yeah, you can amend the claim form prior to service. The only thing I can think of is if the claim form has been served or notified to the defendant, then you'd need to make an application to amend. Okay. Statement of truth is also to be signed by the representative at the end of the direction questionnaire screens for no apparent reason, as there wasn't a statement of truth in the legacy. A really good point. And that is a significant issue that caused me a lot of concern. Someone's going to get their fingers burnt with that. Same with the limitation point. And I very much hope it's no one who's here today. But you can't do much about it other than to make sure you're compliant as far as possible. Someone who's experienced fallen foul of serving the directions questionnaire resulting in an automatic strikeout. Wow. Okay. Well, that's tougher than I would have expected. I would think, David, if you're still online, did you manage to succeed in your application to reinstate? I'd be very surprised if you didn't. If not, I wonder if that isn't more of an error with the technical system than it is with the legalities. 26.38 sets out the sanctions you're potentially exposed to in those circumstances. That's your reference point for that application. If your client qualifies for fee remission, does this mean you should not issue through the DCP? Yeah, I agree. You make a paper application together with an application for fee remission. What do you do if the defendant's legal representative has changed and you've advised the CCMC of that, and the matter is being dealt with offline, but the DCP dismissed the claim because the defence has not been filed on the DCP, and the claimant is in turn not applied for a default judgment? Okay. So, well, let's break that situation down. You've got into the 6-month rule territory, and but the reason you've got into that situation is because the defendant's legal representative has changed. Well, I'd say if you're for the claimant in that situation, you can apply for that to be set aside. You shouldn't have been put in that situation in the first place. not the first time I've had that sort of concern with the DCP. If you're for a defendant, well, nothing to do in that situation, other than to probably consent to the claimant's application, most likely, assuming they apply reasonably promptly. You can file fee remission up to 3 months after the fee is paid. Yeah, I think that. Hi, Elaine, by the way, if you're still there. I think that it is the sort of situation I was dealing with at first. To get it issued under the DCP, you have to pay. Now, if you subsequently ask for fee remission, I would think that is a really good situation to. Sorry, if you subsequently apply for a refund through the fee remission, I would think that is a really good case for the claim coming out of the DCP following an application or a court order of the court's own initiative. But yeah, to get it issued, you'd have to pay up front. You couldn't use fee remission for that. Does it have to be the defendant directly when solicitors are instructed? No, I wouldn't say so. I would say that paragraph 1.9 requires you to serve on the defendant's legal representative, and indeed I go so far as to say that they are obliged to accept service provided that proper notification is being sent to them. On the document sent by the court with the FAQs, it says the claimant will pay the fee in full through the DCP and then apply thereafter if represented. Yeah, that's the situation that's come up a few times now. Makes a lot of sense to me. I'd have thought that takes it out of the portal, but I'd want to. I'm interested in hearing from all of you what your experience has been with that. That's just my gut reaction. Yeah, it would have to come out of the portal at that point, because there'll subsequently be other fees to pay. The hearing fee at the very least, probably an allocation fee. And if you're going to get fee remission for the issue fee, you're probably going to get fee remission for all of those, and you can't then comply with those steps through the DCP. So it almost certainly has to come out, but that's just a gut reaction. First few, another one about the defendant's in-house legal team. I can't see why a legal team, an in-house legal team, shouldn't be able to deal with it. Infant approval claims, Part 8 claim excluded from DCP, paragraph 1.32, I think. No, can't be issued that way. Is there a higher limit to claims that can be issued under the DCP? Well, no. I always assumed that it would be, but no. There is no express upper limit under the rules. The software might impose a limit, but the rules don't. Interestingly, I have to say I thought there would be. What if the first defendant was served via DCP, but the second defendant was added by an amended claim form, which was served by post on the last day it was due? Does this fall out of the DCP portal for DCT for defendant 2? Wow. Blimey. The second defendant contested jurisdiction. That is a question that I'm not going to be able to answer off the cuff. Send me an email if you're still there. That's the sort of thing I'm going to need to do a bit of toing and froing and a bit of interrogation on the exact system on. If I commit to an off the cuff answer, it's going to be wrong. Okay, and last question: will the recording include the questions? Yeah, as far as possible, yes. Okay. If the claim is for more than £50,000, can I issue in the High Court? Yes. In most circumstances, hi, good to see you again. In most circumstances, you can issue in the High Court. Can you do that using DCP? Now, memory goes, no, applies only to county court claims. So if you're eligible to go up to the High Court, so be it. I think that's it. Any other questions? Drop me an email. Let's see who's still here. A very dedicated group of 100 or so of us still here at the end of it. Let me see what I can. Let me see. There have been a few more questions come in just whilst I was reading that. Thank you all very much for coming. Those of you who have to go elsewhere, I fully understand. What are the defendants' insurers dealing with it? Okay. I think I answered that question earlier. In a nutshell, I can't see why an in-house legal team shouldn't be able to use this. Yeah, I don't see why that should be a problem, at least from a defendant point of view. Can only solicitors use DCP, or can claims management companies use DCP? Paul, the only concern I'd have with that is a claims management company issuing a set of proceedings. I'm pretty sure that that's always going to count. I can't see any way. Hello, Lalith, by the way. Good to see you too. I can't see any way that would be anything other than conduct of litigation, which a claims management company couldn't do. Now, have you got, for example, litigation authorization, something from oh gosh, what's the body I'm looking for? The well, you got SRA authorization to do it, or if you've got a solicitor who's authorized to do it in-house, yeah, that should be fine. But my concern in that situation wouldn't be the use of DCP. It would be the use of it would be the claims management company issuing full stop. The DCP isn't just service of a letter before claim or pre-issue negotiations. It is the issue of the claim. So that kind of got to go to the solicitors, I'm afraid. Does DCP cover claims that could have been issued in the small claim jurisdiction? Yeah, it does. Unless it's a road traffic claim, because there's a specific provision that excludes Part 27B, Practice Direction 27B claims. Okay, that's just for us, the last few of us going. And anything else? Someone's pointed out that they work in house and don't have any problems with DCP. Yeah, I think that I think that probably answers my obvious question. That corroborates the preliminary view that I'd come to. So thank you for that. I really appreciate it. As I say, this is all my best guess. This is all very new. There isn't very much in the way of authoritative answers to this yet. So I'm helpful to learn from all of your experiences as well. All I can do is really go through the rules and tell you what I think they mean. Okay. Anything else in the chat box or in the questions box? Failing that, ladies and gentlemen, thank you very, very much indeed. And I think we can probably call that a seminar there.